You've raised a lot of points, but of them all, which do you think may be the most persuasive on the jury on your client's behalf?
I think my remarks concerning the fingerprint are the most important. How effective those remarks were, of course, depends on the jury. But I think that's the question they wanted me to address myself to. Patricia Krenwinkel's fingerprint was found in the rear Sharon Tate master bedroom leading from the bedroom to the pool. And I think that effectively I was able to demonstrate that the fingerprint was placed in an innocent location at a door that was used for ingress and egress. It wasn't found at some incriminating point in the house, wasn't found in the interior of the house, wasn't found at any point of entry, wasn't found at a window or a back window, wasn't found, wasn't in blood. The fingerprint essentially had absolutely no date on it. There's no way to tell when this fingerprint was placed there. The fingerprint could have been put there the 5th, the 6th, the 7th, the 8th. There were 25 other fingerprints in the location that haven't been identified to anyone in terribly incriminating places. At positions very close to where the bodies were discovered, at points where the police opine that the killer or killers gained entry. I think it was the material, the argument in connection with the fingerprints that was most important to the jury. There was other evidence, Diane Lake, Linda Kasabian, but I think essentially Linda Kasabian is a problem of credibility. The jury either believes her or they don't believe her, and I rather suspect that based on her background, history, her character, her demeanor, her ability to communicate, recollect, and perceive, her admissions of untruthfulness, that she's not a believable witness in their eyes. But the physical evidence, the fingerprint, I think was most important to the jury, and hopefully I was more effective there than anywhere else. I hope so.
Have you watched the jury? How do you feel about their reactions to you and what you've told them?
I'm amazed. This jury's been locked up, sequestered for 7 months now. Obviously, this has to be a very boring, trying sort of situation for them, but they're very attentive, sit forward in their chairs, they listen rapidly, many of them take notes. I'm very, very impressed. A very conscientious and earnest jury.
But without a defense case to offer, witnesses and evidence of your own to present, just how persuasive do you think the issues you have raised, how persuasive can they be with the jury?
Well, the beauty, if you can refer to it as beauty, of not putting on a defense is that the defense does not obscure the prosecution. The prosecution's case can be analyzed clearly simply for what it is. And obviously, of course, we are not required to put on a defense. The defendants are presumed innocent, and the prosecution must demonstrate their guilt beyond a reasonable doubt. I think also that if we were to rebut every witness called by the prosecution, we might be here until 1974. I think the jury understands that they don't expect us to become engaged in some sort of rote rebuttal, that for every witness who says yes, we're supposed to put on a witness that says no. I think from the very outset this jury agreed and promised under oath that they'd decide this case on the basis of the evidence, and they were well aware that the defendants need not put on any evidence at all. And of course that's the case. They haven't put on any, and I think the test is whether the prosecution's evidence matches up to that standard of guilt beyond a reasonable doubt.